Mr. Gonzalez, it looks like you're still frozen. Now you're moving.
Yeah, you kind of moving a little bit. You're moving a little bit. It's not age, is it, Mr. Gonzalez?
It could most certainly be age, yes, sir. Or the new knee, one of the two.
Yeah. So if you want to start, Mr. Gonzalez, you know, if we can hear you, great. You're kind of in and out visually.
All right, sir. And I apologize for the trouble. I don't know what I did or did not do. We were fine in the rehearsal.
Happens
But
to us.
I will start, Your Honor, by basically saying the position of the department is that it was incumbent upon the plaintiffs in this case to prove negligence. This case started out as a 1983 case for civil rights. It ended up being a case of simple negligence, and the plaintiffs were required to prove the duty, breach, proximate cause, and legal cause, and we believe that the plaintiffs failed to do so. I want to start with things that I think are important with respect to the representations that were made both at trial and in the brief, and they begin with this idea that there had been a recent commitment of the mother in this case to under the Baker Act. There was no commitment. In fact, the exhibit that was not allowed in but is in as a court exhibit showed that she was transported less than a month before this event that we're talking about in this case. And she was transported shortly after midnight. She was released at 5 o'clock. She was released to the custody of her mother, the grandmother, who is the plaintiff and now the mother of the victim in this case. And there never was a committal. In addition, there was much talk about an incident back in 2008 where the mother had threatened to stab a neighbor's dog. Your Honor, that was the subject of a police report. It started out as an exhibit that was offered by the plaintiffs, and it was an incomplete report because it omitted a supplement that showed that the reporting victim in that case failed to identify Ms. Parker as the perpetrator, and in fact ruled her out affirmatively from a photo pack. And when they were confronted with that, the plaintiffs opted not to introduce that exhibit, and so the defendants tried to introduce it as their exhibit, and the plaintiffs objected, and the objection was sustained, and that's in as a court exhibit as well. So with respect to this idea that there was an incident, that there was a stabbing of a dog or a threatened stabbing, that did not happen. The case of the plaintiffs is stated in the appellate brief, Your Honor, is yes.
If I may, Mr. Gonzalez, because I think you'd agree this case went before a jury. So there's a lot of evidence presented, and the jury became the trier of fact. And didn't at trial, the whole history, the AP's history with DCF, all was presented before the jury. And they brought in the fact of some of the past things that she has done. And let's just exclude the ones that you've mentioned. But everything else that was mentioned, there was evidence presented, was there not, that one of the things that the attorneys really focused on is that the fact that there was no follow-up with DCF, that the protocol usually is for them to contact the police and to find out what occurred. And there was some dispute. Apparently the DCF representative said they left a voicemail. Well, the officer said they never got any voicemail. Well, that's up to the jury to consider the credibility. And so my question to you is that given the evidence that had been presented before the jury in terms of what action DCF should have taken in light of the history of this individual person, given the fact that a prior even investigator said they had cause of concern of having this child be with this mother. Again, factual dispute. The jury came to the conclusion that they believed that DCF was woefully inadequate in their handling this case. So what I'm trying to get at, here we are, we get to sit, we're not the trier of fact, we get to see what all the evidence presented before the court. Some of the things that you've mentioned that you're asking us to kind of reweigh the evidence, and that's not what we should do. You agree with that?
Judge, I'm absolutely not asking this panel to reweigh the evidence. And with everything you said with respect to what there is, in fact, nothing that showed, causation in fact by anything that was or was not done by these agents. These agents, this happened in the first 4 hours of this investigation. When they went out to the location, they put eyes on a child. This came in as a report of neglect, not abuse. They put eyes on the child. They found a happy child. They found a child who was great, and they were met. They were met at basically in the driveway by a person who said she owned the house where all this was happening and had power of attorney. Now, at trial, the plaintiffs poo-pooed the power of attorney and said that didn't make her a custodian. In the trial brief, in the appellate brief, Judge, they're saying that she was a custodian. But with respect to the particular deal about not following up with the police, whether or not they would have followed up with the police, there would have been nothing they would have obtained that would have been grounds for removal or a safety plan, because there was a report from the police officer who said they had left this child in the house because it was a safe environment, that the mother had explained away what appeared to be a suicide note, because what the note said was that if anything happened to her, she wanted to make sure her child was taken care of. And nothing that the police could have told her, because the police testified that when they talked to the mother, their fears of suicide were allayed. And they went about their business and sent it to the deal. And by the way, it's without question, the fact of the matter is that when they went to the house, and laid eyes on the child and saw that she was fine and happy, they did in fact have the mother in that house. And now the plaintiffs say, well, they could have done this. There was not only no legal means that these investigators had to make that mother talk to them. And more to the point, Judge, one of the things that was introduced was a report that was the most recent report about this child, about DCF, and a note in that, and this is the defendant's exhibit, it's in the appendix 2676. It says the mother has a history with DCF, and in all the prior reports, she has refused to speak to the CPI and has also refused access to the home, which was her right to do. And there was no basis that these investigators had to force that person to talk to them, Judge. And so, yes, in answer to your question, we're not asking this panel to reweigh evidence. We're suggesting that there was nothing that showed causation in fact in this case.
And if I may, Mr. Gonzalez, because I think one of the things that, and I hear you say that, you're basically arguing, well, this is kind of an unreasonable, look at all this evidence would not show this. But what we're doing is you're setting forth not the admissibility, basically the weight of that testimony, which is up to the jury to consider. Wasn't there also facts presented that this mother, has lied before, and then she fabricated saying that she gave a different name. All of this stuff was presented to the jury. In addition to that, the history that she had, and when you said, well, she's not being cooperative, well, they had DCF had in their record one of the prior investigator that said that we're really concerned having this child be with the mother. So we can't really just take one or two things in isolation. I think you need to look at the whole totality. And in terms of causation, when you've mentioned causation, was there also evidence presented that with a couple of former DCF employees, that assume this happened, would that be a breach? Would that be, didn't say exactly a breach, but would that be unreasonable? Would that be negligent? And there was acknowledgement that there was. So the jury was given all of this. And the jury weighed all of that. And based on that, they came to the conclusion. And so this is where I'm struggling with, where you may be right that some of these things, maybe the jury shouldn't have considered that or should have gave it little weight, but it's not up to us to reweigh the evidence. That's what I'm driving at, Mr. Gonzalez.
Judge, but it is up to you to demand that the plaintiffs produce evidence that showed that any breach that was committed by them, regardless of what you want to characterize as a breach, they cannot show that any breach was the causation, in fact, of the injury to this ill. No one ever had this person on the map for committing abuse on her daughter. To the contrary, everything in the record was about how she was a caring mother for this child in terms of what was going on. And all they talk about her history back in 2009 and the concern the DCF had. The concern the DCF had was because they had no grounds to take her away, because when they tried to talk to her, she wouldn't come. When they talked to her grandmother, with whom she lived, the grandmother was abusive. And that wasn't given to the jury until very late in this case. And on top of that, after that 2009 report, she was arrested for an event that happened before the 2009 report, but her probation was terminated because of compliance. And the probation officer said that she had no concerns whatsoever for this mother. And what I'm saying is Judge, we're begging the panel to take a look at the record, because whatever the dispute is with respect to whether or not I'm saying that this was something they should have done or had to do, the fact of the matter is there was nothing in there. And the plaintiffs are honest when they say that what they're going on is the record. The complaint that was filed was that the past record of this case, of this mother, made it mandatory that they take away. And that's under a statute that the child can only be removed for probable cause. Nobody's suggesting they had probable cause. And the only other alternative was to have a safety plan. And as it turns out, that child remained with the person who had the power of attorney. There's nothing that shows that anything that these agents could have done would have led or would have made foreseeable what happened in this case. And Your Honor, that's the crux of it. And again, I just want to emphasize over and over again, we absolutely understand that it's not the job of this court to reweigh evidence. We don't want the court to reweigh any piece of evidence. And if the court would like to point out to something that they think is, then I'd be glad to address it. But we just believe that there has been no proof, that there has been no proof of a breach of a duty to remove the child, which is what the plaintiffs describe on appeal as the crux of their case. And they're honest enough to say that the theory was that the child should have been removed way back in 2009, and there was no legal basis for that removal, and there was no legal basis for anything that wasn't done in this case. And I'll reserve whatever remaining time I have, Your Honor.
Thank you, Mr. Gonzalez. You have about 6 minutes.
Thank you.
Okay. Applee, you're up.
Good morning, Your Honors. May it please the court, Tom Sider with Brannick Berman and Sider for the plaintiffs. This is an appeal from a jury verdict returned in favor of LXC, who was 6 years old when her mother stabbed her. The jury here was tasked with considering and weighing the evidence. There was a lot of it. There was 2 weeks worth of evidence. Over 20 witnesses testified. There were thousands of pages of exhibits. And after considering all of this evidence, the jury returned a verdict finding that DCF had been negligent. And it is that verdict that DCF asked this court to take away now.
Mr. Sider, if I may, what Mr. Gonzalez is saying, that apparently the causation element, as I hear him, that seems to be missing, that this was not proven at trial. So why don't you focus on that for me, if you can?
Yes, Your Honor. I think the easiest way to resolve the causation question is by focusing on the evidence here that DCF was negligent in not identifying AP at the door. And we, I think, had given the jury a lot of different ways in which the investigators have been negligent in not identifying her. And one of the investigators, Apollonia Tucker, when she is asked about, well, what could you have done if you had identified the mom? There is testimony before the jury that and I'll find the quote here, if we had known that mom was behind that door, we could have probably made a different assessment. We could have probably put a safety plan in. And that's at 2001 to 2002 of the trial transcripts. And so that's not the only evidence by any means, but I would say it is the most straightforward line that you can draw from the alleged negligence here, the proven negligence here, and then cause and fact. Tucker is saying, she's even using the word probably. That's the preponderance standard. That is more likely than not. And so if a safety plan gets put in, the daughter goes with her grandmother, and DCF has time to investigate the mother. And most importantly, the daughter is not in her mother's care the next day and is not stabbed. I mean, that is the causation and fact argument here. And it is pretty straightforward. You know, I think there is also this argument about foreseeability, and this same testimony about the safety plan undoes that argument as well. Safety plans can only get put in, or only need to be put in, by Tucker's own admission if there is the child is in imminent danger. And so by saying we would have put a safety plan in, there's an implicit acknowledgement that there was an imminent danger that they could have perceived had they known it was the mother. So that takes care of both of the elements of causation, both causation in fact and this foreseeability analysis. And, you know, Mr. Gonzalez has sort of suggested today that, well, the mom was so unreasonable. Who's to say that there was any kind of likelihood that she would have agreed to a safety plan? Well, the person who said it is DCF's own agent. And so the jury didn't have to make any sort of great inferential leap here to find causation. They just had to take DCF's witness at her word. You know, there's also a lot of other evidence from which the jury could infer evidence here. I think the police reports, had they been reviewed, and they were supposed to be reviewed pre-commencement, that's what DCF's policy was. Had they been reviewed, you know, I think a very reasonable inference to draw is that an agent, a reasonable DCF investigator, would have gotten LXC out of that house and away from this woman who's experiencing what seemed to be psychotic episodes. And it's not just that she was mentally ill, you know, she was imagining things that weren't there. Police were coming out to the house. The police had to take her away one night. Whether she was committed or not, she was taken to a facility to be inspected because the police saw that she believed that there was a man holding a gun to her head who was not there. And that's all while the daughter's at the house. The mother at the same time is saying that she thinks that she has seen rather a video of the daughter being sexually abused. And that is the same day that the daughter is reporting genital pain, and there are observable signs of her genitals being red and inflamed. And so, you know, these are all things where I think a reasonable jury could say, knowing all of this, had the agents known all this, they would have gotten her out of there. And as you observed, Judge Guzam, I think a major problem with these unforeseeability arguments is that DCF's own investigator back at not long after LXC was born predicted that this was going to happen. This investigator wanted LXC to be taken away. He begged for it. He was the one that was closest to this investigation. And he writes in the file, you know, this mother's behavior is so erratic that I'm worried she's going to hurt the daughter one day. So not only was this eventuality foreseeable, it was in fact foreseen by DCF. And DCF can't now claim, as it has to if it wants to win a directed verdict on causation, DCF can't claim that this event was so extraordinary or bizarre or highly unusual that they could not possibly have foreseen it. The only other thing I'll say, Your Honor, is back to this idea that this was only, you know, a few hours that these investigators had to make this decision. The investigators had knew about AP's long history with DCF. They knew from her records that she was, you know, had been erratic, that she had abused children in the past. You know, there's the matter of her burning a young child that was in her care. The jury saw the photos of those burns, and they were pretty gruesome, quite frankly, and they are in the record at 8,263. They were third-degree burns. This was not some glancing, touch of a space heater. They were serious. The jury could easily have inferred that this was not something that happened by accident. And the jury would have paired this fact with the daughter as a young child being, according to the mother, dropped on the ground many times, resulting in bruises. And the foster child who had been burned had also shown up bruised at school. And so all of these things together, the jury could infer that this mother, the children in her care did not keep getting injured by happenstance or coincidence. It was because of intentional conduct. That is what the DCF agent assigned to the file thought at the time. He thought that the mother was actually, or had actually, hurt the children, and he wanted to take LXC away as a result. So with that is the background that the investigators went into the night in question knowing, and especially against that backdrop, their actions on the night in question were certainly negligent. I won't belabor them. I know that they've been covered in pretty great detail in the brief, but they were supposed to look up the DCF, the police history. They didn't. They were supposed to contact the officer who had reported AP to the DCF. They didn't. They were supposed to make diligent efforts to identify AP. They did not. And it's not just that they didn't do one of these things, any one of which would be negligence. It's that they did not do any of them. They did exactly none of these things, and then they left LXC behind. And there is, at the very least, the jury could have drawn from that evidence the inference that DCF's investigators had been negligent on the night in question. And unless the panel has any further questions, we would ask that this court affirm the final judgment that was entered on the jury's verdict. Thank you.
Hey, Mr. Gonzalez, you're up to rebut.
Thank you, Judge. I will start with the notation that opposing counsel wasn't trial counsel, obviously, but with respect to the representations about this record, it's just imperative that the court look at the record and not the argument. Starting with the fact about the abuse, there was no charge against the mother for abuse. It was neglect, and the neglect was that she allowed this child somehow to be harmed, and that was followed by 5-year probation that was terminated early for compliance, with a probationary officer saying she had no concerns for this mother as a mother in terms of what's going on. With respect to this drumbeat of mental illness and that being a cause for taking away a child, we've cited the cases in the brief that a history of mental illness can't be a cause for removal unless there's a nexus between the behavior and some harm to the child. And there is nothing in this record that would allow anyone to find a nexus between any mental condition that this had or did not have and harm to the child. And I go back again to the report of what was a committal and now without shame is backed off and saying, oh yeah, she was just transported. After 4 hours, it was found that the suicidal risk assessment was completed. She denied suicidal or homicidal thoughts and no safety or harm or risk observed. And with respect to the most important thing that we've been trying to talk about, with the way that the appellee is talking about causation and fact, this whole question of what they had when they came there, this person wasn't identified in the presence of a person who said she had the power of attorney, and in a interview subsequent to the stabbing said that the reason that she got the power of attorney was so that DCF wouldn't take her baby away from her. And in that moment where the plaintiff now says she couldn't hear for any number of reasons, or she didn't understand, or whatever it was, there is nothing that shows that these investigators had knowledge of that. What they observed is they asked to see the child. They testified that they were told that the mother wasn't there. The plaintiff admitted that what she said was that the mother came and went between Orlando, but there was no question but that when the door opened a crack and this person who identified herself erroneously was there, that grandmother with the power of attorney was standing there, and there is no way that anyone can show that these investigators had knowledge of that fact. And so when we get down to the fact of removal, it takes probable cause. Nothing that these investigators had constituted probable cause. What the plaintiffs are trying to do is they're trying to miss the concept of a threat of imminent danger and probable cause. Because when you're talking about a person being taken involuntarily away from her mother, then you are not talking about a safety plan. A safety plan is something that can be suggested by the investigators and has to be agreed to by the parent. And that's the only way it can be. Now, again, playing at both sides in the appellate brief, the plaintiffs are now saying, well, they could have done that because although we argued at trial that having a power of attorney doesn't mean custody, they now say in their appellate brief that, well, this grandmother was a legal custodian. So she could have agreed to a safety plan. The only way that a safety plan could be implemented with the agreement of the parent, and there was no threat of imminent harm when they came. When they were called out, they were called out on a potential neglect case. It was never about abuse. They got there within 4 hours. Had they gotten there within the 2 hours the plaintiffs say they should have gotten, they wouldn't have found anybody, because the undisputed testimony was that the grandmother arrived from the hospital on a bus about the same time as the mother was coming up the driveway. When they got there, they got to see the child. The child was happy-go-lucky, happy. The grandmother was there and testifying to the fact that the child was fine and everything else. And to say that had they known that was in fact the mother and what was going on, the citation that was given that I would ask the court to look at after this argument as to the proof as to what could have been done had they investigated is a reference to a deposition that was used by the plaintiffs to confront the witness after the witness said, no, it wouldn't have changed anything. And then she was confronted with the testimony, and the testimony in the deposition was, had the mother been identified and said all this stuff, then we might have made a different question. There is nothing in the world to suggest that this mother would have ever said anything like that. She hadn't said it to the police hours earlier. She hadn't said it every time the DCF tried to talk to her before. And with respect to that earlier 2009, in terms of what the deal was, the whole thing was, and by the way, when the plaintiffs now say that she was dropped multiple times, the appendix 56, page 56, is the final summary of that. And it talks about, according to hospital records, there have been 2 occasions when the child has been so grossly mishandled that she was allowed to fall to the floor from a height of 24 inches and to the sidewalk from a height of 12 inches. In the first case, the child was taken to the hospital and no injury was observed. In the second case, she took the child to the hospital but didn't wait around. 5 days later, she brought the child to DCF, and DCF performed a scan, and there was no injury.
Okay, Mr. Gonzalez, you have kind of exceeded your time here, so you need to wrap up.
I appreciate the indulgence, Judge. Thank you.
Okay, thank you both very much. In order to leave our courtroom, such as it is, you click the button on your Zoom screen labeled Leave, and you'll go away.
Thank you, Judge.
Thank you. Okay, our next case is Quill versus et al. Versus Palin.